What kind of acts can revoke a will? To find out, you have to read Matter of Lewis. But it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I normally cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is part of a limited series I'm doing on cases relevant to the elder law and estate planning community. This is the case of Matter of Lewis, published by the New York Court of Appeals on June 4th of 2015, and the citation is 25 New York 3rd, 456. The issue in this case is, when is a will revoked? To appreciate the context of this case, a little background knowledge would be helpful, which is, first, a will is a written document written by what we call a testator, describing what they want done with their property after they die, and also sometimes naming an executor, which is a person who's charged with distributing the property in accordance with the will. With respect to divorce, EPTL, which is the Estates Powers Trust Law, which describes and defines a lot of these rules about wills and last wills and testament, says that a divorce, the EPTL 5-1.4 says, divorce revokes the bequest to the former spouse. So if you're married and you give everything to your spouse and then you get divorced, it's as if the spouse predeceased you. That's how the will gets distributed. But it does not revoke bequests to in-laws or individual named people that are not your spouse. The other thing you have to know is that EPTL 3-4.1 describes how you can revoke a will. You can revoke a will by a new will, by a written revocation, which has to have the same formalities as the original document being executed, or destruction. Destruction either by the testator, him or herself, or by destruction at the hands of somebody else at the direction of the testator. And the last thing you have to know is that there's a presumption that if the testator, the person who drafted the will and whose will it is, has possession of the will, and then they die and no one can find the will after a diligent search, then it's presumed that the testator destroyed the will. Okay, so what are the facts here? The facts are that the subject in this case is Robin Lewis. Robin Lewis, in 1996, she was married to someone named James Simmons, and Robin executed a will. So did James Simmons in 1996. They executed it in Texas in quadruplicate, meaning in 4. It's not clear whether it's 4 originals or 1 original and 3 copies, but James Simmons testified in the course of this proceeding that 4 of the documents were drafted with the expectation that each of the 4 would be functional instruments. Each of the 4 would be capable of being proposed for probate. They left 1 in the Texas house, 1 in the New York house, 1 with James's parents, and 1 in a safety deposit box. In 2007, 9 years later, the marriage ended in divorce without any children. And in 2010, Robin died. So she dies, and she dies in the New York house, which she gets as a part of the divorce. And when they do a diligent search, they can't find any will. They don't know if any will exists. So they administer the estate as if there was no will, and it goes to Robin's parents, who then allow it to go to their children, which is Robin's brothers. At that point, out from the woodwork come Robin's former father-in-law, who received under the will, right? And he's not revoked as a matter of law by the divorce because he's a named person who was not her spouse. And he says, look, I've got this 1996 will. Here it is, surrogate, probate it. And during the proceeding about whether to probate the 1996 will or to use the letters of administration as if there is no will, the best friend of Robin testifies, Mary Lou. Her name is Mary Lou, and she testifies in 2007, right around the time of the divorce. I had a long conversation with Robin, and she wanted to revoke that 1996 will. In fact, I saw her holding a revocation document, and we discussed it. But I never saw her sign the revocation document. At the close of that testimony, the surrogate, who has the choice between the 1996 will and having no will, says, I feel bound to probate the 1996 will because mere discussions about revocation is not sufficient. It goes to the appellate division, they agree with the surrogate, and then it goes to the Court of Appeals. And here, the Court of Appeals says the surrogate was right about the discussion of revocation. If the question is, did that discussion that Mary Lou witnessed with Robin about she wanted to revoke the will, she looked at a document that would revoke the will, does that sufficient to revoke a will? It's not. Just as we talked about in the background. To revoke a will, a document that revokes will has to have the same formalities as an actual will execution. You have to have witnesses. It's got the whole ceremony that you would do for a will execution is the same as what you do for a will revocation. So that discussion does not revoke the 1996 will. But the Court of Appeals says there's another problem that they're identifying here. They're saying Robin died, and she, when she was alive in that New York house, had a copy of the 1996 will. And when she died and they searched her house, they couldn't find it. So they say, what you're forgetting, everybody, is that there's a strong presumption that the will was destroyed by the testator, by Robin, because she had it, she died, and we can't find it. And in that circumstance, there's a strong presumption that the testator destroyed the will, and that presumption has to be rebutted by the proponent of the offered will. So they say this was never really addressed in front of the surrogate, so they're going to send it back down for the surrogate to discuss and address that issue. Does the former father-in-law, have evidence to rebut that strong presumption that the will was destroyed by the testator? That's the question that remains here, and that's the discussion of what revokes a will in the case of matter of Lewis. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.